My name's Molly Mary. I was just recently appointed as Division Director of Risk Management, actually about 2 or 3 weeks ago. For those of you who may have known R.J. Castellanos, who was our longtime director, he just retired a few weeks ago. And I've been the Assistant Director for the last almost 4 years, and so I was just recently appointed as Director. So I'd first like to thank DMS for inviting us to speak here today. We work very closely with all of our state agencies on a day-to-day basis, but it's unusual that we actually get a chance to come speak at a seminar like this to talk to you a little bit about what we do and what our role is with your claims. So I appreciate very much the invitation and the chance to speak today. With me today, I've got Mark Stimley, who is our Bureau Chief over State Liability and Property Claims. He's also fairly recently promoted into that position. Ray Williams was in that position prior to that, and some of you may have worked with Ray over the years, but he actually retired as well. And then we have Renee Gordon, who is Assistant General Counsel for the department, and Kim Fluharty-Denson, who is an Executive Senior Attorney, also with our General Counsel's office. So we're going to kind of have a panel or switch in and out to talk about several topics today. I'm going to kind of talk a little bit about the background for the division, tell you a little bit about what we do and what our role is in settling your claims, and also talk a little bit about premiums, because we get a lot of questions sometimes when we're trying to make a decision about settling a claim and what that impact could have on your premiums. So I thought I would speak a little bit about how we do premiums so you have a little bit of an understanding about how that process works. Then Mark's going to come up and get it a little more detailed into our actual FCR and employment claims and talk about our certificate of coverage and things like that. And then Renee's going to give a perspective from a general counsel's perspective and some of her background as well when she was at the AG's office that I think will be interesting. I know, sorry if I'm a little croupy. I've had a little bit of the crud and I'm not quite over it, so hopefully my voice will hold out. A little bit of background on the division. We were created in 1972, and all of our duties are outlined in Chapter 284 of the Florida statutes. Prior to that time, we enjoyed sovereign immunity, and so we had immunity on tort claims. But when that changed in 1972, the legislature realized that they needed to actually set up an agency to handle all the insurance coverage needs for the agencies when these claims started coming in. So currently today we offer coverage to 47 state agencies and universities that are provided coverage by the division. We also have 10 other entities that are statutorily required to be covered by our program, and those are entities like PRIDE, Guardian Ad Litem, Developmental Disabilities Council, entities like that that are statutorily created that we also cover. So there's like about 57 entities in total that we deal with. The trust fund that we use is called the Risk Management Trust Fund. That's a self-insured fund, and it was created to provide the 6 coverage lines that we provide to you as the state agencies. The first coverage is federal civil rights and employment, which is the focus of the seminar today, but we also have general liability, auto liability, court-awarded attorney fees, workers' comp, and property. By far, workers' comp is actually our biggest animal there. I mean, it takes up a good bit of our budget. It actually takes up about 87% of all of our payouts that we do during a year are for workers' comp. So out of about we actually pay out for comp $107 million a year in benefit payments, and that's 87% of everything we pay out. To kind of contrast that, the FCR and employment piece is about $6 to $7 million a year. So that's like this, and comp is huge. But obviously FCR and employment is critical from a program perspective at your agencies. It's very important. We're funded by premiums, obviously, that we charge to the agencies. And then they fund us basically on a cash flow basis. So we only collect premiums for the upcoming year for what we need to pay out in claims for that next year. So that's why we call it a cash flow basis. So that means we're only collecting, like I said, around 100, can't remember the exact figure, but it's about 140 or 150 million in total premiums for everything. But actually, we're not like an insurance company. A typical insurance company is going to have premiums that cover all the claims that were incurred in that year for the life of those claims. So we actually have a huge unfunded liability because we only collect what we need for the next year. So we actually have about $1.2 billion unfunded liability. If we stopped business today and took in no more claims but had to pay them, all the rest of them out that have already been incurred, it would be a $1.2 billion. So that's pretty interesting. As far as agency and university responsibilities, Section 284.385 basically requires agencies covered by our fund to immediately notify us if you have a claim and cooperate with our division to help resolve that claim. Basically, the statute says no such claim can be compromised or settled for monetary compensation without prior approval of the Department of Financial Services, specifically risk management, and prior notification to the covered agencies. So basically, there's some responsibilities on both sides. Y'all as agencies have responsibility to let us know about these claims and work with us, and we also have a responsibility to work with you and take that into consideration, your needs as well. As far as the communication goes and the authority, we technically have the ability to settle a claim without your approval, but that's not our philosophy. Our philosophy is that we want to involve you every step of the way. We want to notify you of any significant events that are happening in the claim, and we want to seek your input anytime we're looking at settling the claim or trying to make a decision between settling it versus going to trial. We feel like you are our customers, and we put a very high emphasis on that, and we want to make sure we're doing that. If you ever feel at a time we're not doing that, you need to let us know that, because that is our philosophy. As far as just an overview of the claims process, I'm going to kind of go high level, and then Mark's probably going to talk in a little bit more detail. But from a high level, we do employ claims adjusters. Our FCR and employment unit has a supervisor and 5 adjusters, some of which are here today. So they handle the claim, they take it in, they investigate it, they look at what your potential damages are, they look at the legal liability, and then once that claim goes into litigation, we then retain an attorney on your behalf to handle that claim. We have about 150 law firms all around the state that are on contract with our department, as well as the Attorney General's office. And we decide, along with the agency, who's the best attorney to handle that claim based on, the situation with the claim, the specifics, what's the coverage, just expertise of a particular attorney, and also what your preference is, because some of you, work with certain attorneys and you're very comfortable with them. So we do our best to try to accommodate your needs when we can. Basically, once it goes into litigation, our adjusters are going to work with that defense attorney, and they're going to work with your agency every step of the way through that claim. And they're going to supervise the litigation of it. They're going to stay in touch with the attorneys. They're going to read reports that the attorneys provide to us, and they're also going to attend mediations when those occur. Once we kind of get to a certain point where we have to decide, are we going to settle, are we going to go to trial, our adjusters are going to basically let you know as an agency, here's where we are, this is what our recommendations are, this is what the defense attorney is recommending, and we're all going to kind of get our heads together and decide what we're going to do. The vast majority of the time, we're able to reach a consensus on what we're going to do. We do have a fiduciary responsibility to the trust fund. It's funded by premiums. Those are taxpayer dollars. So we do have to make sure we're settling the claim in what we believe is the best interest of the state and the fund. But like I said, most of the time, we don't really have a big issue. Most of the time, we're able to resolve those and come to a consensus on how everybody wants to handle the claim. We talk sometimes about, why risk management was created as a separate entity, separate from the state agencies. Well, basically, the legislature wanted an independent agency that was staffed with adjusters, that were trained specifically to adjust claims, and had that expertise to do that, and maybe wouldn't be influenced as much by the personal side of some of these HR claims can get pretty strong. And you feel like you've done everything right. But as an independent entity, we can step back a little bit and see how sometimes things go south, even when you've done everything right. And so we try to bring that perspective to the claims. So even though we have the authority to do it, it would be very rare that we would just decide we're going to do this without your input. You're going to be involved every step of the way. Our goal, like I said, we've got to fairly adjust the claims economically and as quickly as possible, keeping in mind your concerns, but keeping in mind the financial aspects of the fund and making sure the fund stays strong. Premiums, like I said, I wanted to talk just a little bit about premiums because we get this question a lot, and it's really hard to explain why we can't answer your question. When you're looking at a settlement and maybe you're going to have to settle for $200,000, and we get this question a lot sometimes of, Well, what's that going to do to our premiums next year? That's a really hard question to answer because of how complicated the premium calculations are, but I thought I would at least give you a flavor of how we do those calculations and how the fund is supported. We have a revenue estimating conference. I don't know how familiar some of you are with that, but that's our economic and demographic research group that's part of the legislature. And then there's representatives from the governor's office and the House and Senate that sit on that REC, as we call it. They actually determine what our total premium is going to be each year. So it's not us deciding it, it's them deciding it. So we actually meet with them about 3 times a year, and they look at our revenues and expenditures, and they decide how much risk management's going to need in the upcoming year to support its program. So in the last several years, the REC has set our annual premium at $175 million per year. Of that amount, about $11 million was allocated to the FCR and employment function, that coverage line. And that generally has not changed much in the last 3 or 4 years. Your premiums are due in July of each year. That covers you for that whole fiscal year premium for coverage. Even if you have a claim during the year, you pay that premium in July, you have a bad claim sometime in the middle of the year, we don't come back during that year and say, we need some more money. We've got our money for that year. So any settlement we do or judgment that happens during the year, that's done. There's no impact on your budget for that fiscal year. And all the claim costs, including the defense attorney fees, are paid out of the pot for that year. Now, when we actually run the calculations for your premiums, that's run in May or June of each year, getting ready for those bills to go out July 1st. And we look at both your exposure, which is like your FTEs. That would be for employment, and FCR, that's going to be the number of employees you have, and can also include volunteers and agents if your agency has those. So you got an exposure piece, and then you've got a loss history piece. And that loss history also includes kind of 2 components. One is recent claims that you just had in the last year, and then there's an average historical loss period. And that for FCR claims and employment, that's 10 years. So there's 2 pieces of that. One is to give you the benefit if you've had a good loss prevention program in place and you're reducing your claims close to current period, you get some benefit of that. But then we also have to look at the historical losses because the FCR and employment claims have a tendency to be a lot longer. And so we actually look at a 10-year period on those. I'm not going to go through all these percentages, but you can look at it when you have time. But basically, there's certain percentages that are weighted depending on whether you're looking at your exposure or your loss histories. And so we literally have this for FCR and employment, we have $11 million to split all among the 57 entities we cover, and all these go into this calculation to decide how much your particular agency has to pay for premium. Now, as far as settlement impacts on premium, which is what I was trying to get back to, it's really hard to say, like I said, what a particular settlement is going to impact because of all these factors and the fact that the total premium for the state is set. So if you have to pay out $200,000 for a settlement this year, when we come around to June and run those calculations, the impact of that depends on how you did with everything else that year and how all the other 57 entities did that year. So you might have a bad loss, but another agency might have an even worse loss. And all we're doing is moving that $11 million around depending on all these factors. And so it's just very difficult for us to answer that question. A lot of times we won't know until we get to that particular time when we run the calculations. If you have any specific questions about premiums, we have 2 or 3 staff that are experts in how our premiums work, and we'll be happy to sit down with you, and you can just give us a call, and we'll sit down and actually show you how your premiums work. It may not impact some of you in the room here, but a lot of your financial managers and your budget people are very interested in how this works. So if you ever need more time to take a look at this, just let us know. So that's all I had. I'm going to ask Mark to come up now and actually get more specific on the employment and FCR pieces.
Hello, I'm Mark Stemley. I am the Bureau Chief for State Liability Claims. As Molly said, I have the pleasure of working with a bureau that consists of a lot of very experienced claims adjusters. I have a staff that on average has 20 years adjusting authority, 20 years adjusting experience, and have been with the division for a very long period of time. What I'd like to talk about today is when to get risk involved. The pre-suits are not an area that we take care of for you. We don't hire an attorney to file a response for you. That's the agency's responsibility. And that's why our involvement generally comes into play at that point. When the agency receives the charge and files a response, risk can then get involved. If you come to us pre-suit, if you look at the facts in the case and it's something that you want to get settled, come see us and we can talk about it and see if we can't get it resolved. And really the benefit to that is then you don't get into incurring a lot of attorney fees and expenses, and sometimes we're successful in getting them knocked out pre-suit. The role of risk management is one that once we receive the case from you, we set it up in our claims management system. We assign it to a particular adjuster who works it throughout the life of the claim. And then we hire outside counsel. Rob would get involved with us at that point. And then the process that he comes gets with the agency, talks to witnesses, looks what the facts are, and we try to get an early idea of what we're dealing with. And based on that, we come up with a plan of defense and make a decision based on the input from the agency, also the input from the adjuster and the attorney that's hired. And we look at all those factors, and keeping the adjuster in the loop all along, risk management staff then makes the decision as whether this is a case that we dig in on and really fight hard, or it's something that we try to push towards settlement and get an early settlement before there's any more discovery that's done that is damaging to our case overall. The federal civil rights coverage that we provide is under 42 U.S.C. 1983 and other statutes that are similar to that, and they're adding them. We have a list of things that we cover, and if a new statute is passed that impacts the agencies, then our coverage extends to that. It includes the payment for the settlement of the claims themselves, and then it also includes a payment for attorney's fees. And as everyone knows that's worked on these cases, oftentimes you can have a ridiculously small award and you get tagged with very large attorney fees. You've got the fees of defending the case, but more importantly, you've got the fees of the plaintiff's attorney that brought the thing in the first place, and that's the main driver behind all the litigation. Under the employment discrimination coverage that we provide, and there's a certificate for each of these, we pay all the sums that the insured would become legally obligated for, subject to exclusions, and that's paid under statutes such as 42 U.S.C. 2000, Title VII claims, the Rehab Act, and other similar statutes. And kind of roll up here to talk about some of the others. The Florida Whistleblower Act, as we've talked about, is an extremely active area of litigation for us. It's a big expense driver. Workers' comp retaliation and the Family Medical Leave Act are other areas, along with 760, that we're seeing be very active from a litigation standpoint. What we did here, we took a look at the last 3 years and looked at the frequency of the type of claims that we were getting in. And as you can see, whistleblower is the main culprit, followed by termination due to race, retaliation, termination due to disability, and disparate treatment due to race would make up the top 5 as far as frequency within the last 3. As to cost over the last 3 years, you can see whistleblower is leading the pack once again. And I think that's a function of it's a fairly low bar. There's no caps on anything involved with it. And it's just a very active piece of the litigation puzzle right at the moment. In addition to that, terminated due to disability is the next most costly for the division, along with retaliation, termination due to race, and termination due to age would round out the top 5 in cost for us. Some of the exclusions in the certificate that I want to make you aware of are the Risk Management Insurance Trust Fund does not pay for punitive damages. So if there's an award of punitive damages, that's not something that you can look to risk management to take care of, or to actions that are committed in bad faith or with malicious purpose or a manner exhibiting willful or wanton conduct that was intended to cause harm. They're specifically excluded in the certificate of coverage. In addition to that, the trust fund does not pay any final judgments in which the insured was found to have caused the harm intentionally. So if it's determined and adjudicated that it's an intentional act, then that's not something we can pay on. Two awards for injunctive or prospective relief, neither of those things are covered. There are instances where we can't cover the underlying, but we do defend the case and could take care of some of the attorney fees. The fund will not pay any costs associated with implementing or monitoring declaratory or injunctive or prospective relief awards. And the area that comes into the most is having to do with the front pay aspect of settling these claims. Certain types of cases that are brought have that as a component. And it may be a situation where the front pay is awarded, and if it is awarded, that's something the agency has to take care of. In a settlement negotiation where we're trying to get a case resolved, and we think it's in everybody's best interest to do so, risk management can pay the back pay, we can pay the attorney's fees, we can pay a damage award, but we don't pay prospective relief, and front pay is prospective in nature. So that is always the responsibility of the agency. If there's an occurrence, we need to get written notice to the department, to the Division of Risk Management as quickly as possible. And with specificity, we need the time and the place, anything that you can give us so that we can share that with our attorney that we hire to help and assist in defending the claim is what we're looking for. And oftentimes in helping us run down witnesses is an area that's much needed because, you know, the key witness is the one that's always the hardest to find. So, you know, any information you can give us and, you know, records that you can share with our attorney and with the adjuster that's working the file, you know, is always appreciated. The insured's duties. If a suit is brought against the insured, the insured should send any demands, notices, summons, anything like that, share them with the defense attorney or risk management, the adjuster that's working the file. And failure by the insured to advise the fund of a claim prior to suit or any kind of settlement agreement on that suit is something that would void coverage. So unfortunately, we have had instances, albeit very rarely, where by the time we find out about a case, it's already going on, and they've already approached the other side and obligated themselves to some kind of settlement. And that's just not something that's allowed under the certificate. And don't knock on our door and expect that after the fact, after the horse is out of the barn, that we're going to come fix that. It's something we can't do. And like I say, that's very, very rarely, but it is something that you do need to be aware of. The certificate of coverage indicates that, you know, the insured should cooperate with the fund. You should make folks available for attending hearings, attending trials, depositions, securing any evidence that, you know, is out there and available, and helping with the attendance of witnesses. And once again, don't, you know, be going and making any, you know, voluntary payments or assume any obligation unless if an individual is sued individually and they want to dip into their pocket and settle a claim, they do have the right to do that. But that's not something they can obligate risk management to. As far as evaluating cases for settlement or defense, we have several tools we use. We have a tool called CFIS. It was developed by R.J. Castellanos, our director, that had worked there for many years, and it allows us to put a numeric score on claims and takes into account a lot of aspects of the file and reduces it down to a number. The higher the number, the worse the case is, the more we try to get those settled early on is the useful part of that tool. Also, we have something called a consolidated report. The consolidated report is written by the claims adjuster that's been assigned to the file, and it encompasses the thoughts of the adjuster. It takes into account the wishes of the agency, and it also encompasses the report that's written prior to settlement or prior to trial that the defense attorney, all the information, and it encompasses all the information that they've shared. These are important evaluation tools, and any big case goes before claims committee, which is the senior management of risk management, and we sit collectively and review all the different aspects of the case. And we look at things like what was uncovered during discovery, what burdens of proof are there given the type of case it is, and whether or not, you know, there's any possibility of summary judgment at the onset, and overall just kind of the strengths and weaknesses of the individual file. We also look at what's going to be able to be presented or testified to at trial, whether or not our witnesses are credible, what kind of appearance they're going to make, and, you know, who's trying the case for us and who they're trying it against. What judge is it in front of? Is it a judge that has favorably ruled on similar cases for us in the past? Or is it in front of a judge that has, on the last 6 occasions that we've tried cases very similar to this, just hammered us? So we look at those particulars. We have a fairly small pool of judges that these cases get tried in front of because we try to move them to federal court. Rob spoke to that we feel we get a much more even treatment, and we can predict the outcome a little bit better rather than leaving them in state court. So if it's at all possible, we try to move them. And then we look at what damages are available, because, you know, each of these has a different component as to what they're able to claim and whether or not the thing's capped. We talked a little bit earlier about 760. You know, we enjoy a cap there, whereas on the whistleblower stuff we don't. So that's certainly taken into account. And in conclusion, I just want to say that it's really our mission to resolve cases. And we do that whenever possible. We vigorously defend cases when we feel we're in the right. We hire good outside counsel. The AG works closely with us on a number of these cases, and they do a good job for us. And Our job really is to pick winners. And it's a tough job, but we consistently have pretty good results and try to get a fair resolution that keeps our customers, the agencies, happy. Thank you. Next up is Renee Gordon.
Good afternoon, everyone. I'm talking through a cold, so excuse me. Hopefully all of you can hear me okay in the back. As Mark mentioned, my name is Renee Gordon. I'm Assistant General Counsel with the Department of Financial Services. Prior to my current position, I worked at the Office of the Attorney General in the Employment Litigation Bureau under the guidance of Mr. Glenn Bassett, who's in the back of the room. And I currently work with Kim Fluharty-Denson, who's been with the agency for about 7.5 years. She's an executive senior attorney with DFS. When I was at the Attorney General's office, I defended state agencies just as Rob does and as Glenn does in discrimination cases and retaliation cases and other cases that were filed in state court or even in federal court. Most of my cases actually were in federal court. Today, we thought it would be useful to share a couple of general guidelines that both Kim and I have gleaned from dealing with these cases over time. Those general guidelines, let's see if I can figure out how to do that, okay, can be summed up in 3 words: document, enforce, and evaluate. For the most part, when I was at the AG's office, I found that state agencies did a very good job of documenting problems with employees. But there were occasions where we didn't have sufficient documentation to prove up an adverse action. There were a couple times that I reviewed a case file and I wished that there was some sort of note, some writing somewhere, something in the evaluations that told me this really was a poorly performing employee, and that did not always happen. I recall one case in particular where an agency had fired an employee for poor performance, and when I received the case file and looked at her evaluations, I saw that she had had 4.0 evaluations, not just for 1 or 2 years, pretty much for the entire time she'd been there, and she'd been there for a while. She was a long-term employee. Once the agency realized that this was a problem, they went ahead and moved quickly to try to resolve that case very early on. In fact, it may have been prior to her deposition. So we can't stress enough the importance of documentation. That is absolutely critical to defending your cases. The second guideline we want to point out today is enforcing written policies consistently. That was not always something I saw, but every now and then I would see where inadvertently an agency may have applied a policy unequally. And I remember one case in particular where a gentleman had been terminated for not reporting his criminal history properly on his application. Well, when we look back at other cases that were similar in the agency, we found that other employees had done the same. Well, this gentleman was terminated, and those employees received written reprimands. You can imagine the problem that caused when we realized that. So generally, we have to make a really good point of telling managers to, across the board, apply those policies equally to all of your employees. That helps down the line when you're defending a lawsuit, especially in a discrimination lawsuit. And the last guideline that we came up with was basically something Rob had spoken about earlier, which is evaluating cases at the administrative stage. Now, we all know when we get charges of discrimination, we don't always have a lot of time to really conduct a thorough investigation, but that is the best time to do that. to get all your ducks lined up in a row so that you can decide who the strong witnesses are, who your weak witnesses are, how much time this is going to take out of the agency's day to go to a trial or a hearing. You really want to evaluate up front so that you know the costs and the risks associated with going to trial. I also think that once you've done a thorough investigation, you can write a thorough position statement. And that often will deter claimants from even filing lawsuits to begin with. If you outline all the problems that you had with that employee, and they're well aware that you're aware, and plan on bringing out all this information in court or in a hearing, then they'll be less inclined to take the case further. So those are basically the guidelines that we thought of: document, enforce, and evaluate. Now, Kim, who's here with me today, would like to speak a little bit more about her experiences with these sorts of guidelines, and she's on her way up. Okay, thanks.
Good afternoon. My name is Kim Fluharty-Denson. I work with the Department of Financial Services. I've had the pleasure of handling their personnel cases since 2009. I work very closely with Renee and with HR. It's a very important part of our job is to really rely on what the HR professionals teach us, because I learn every day from Liz Kelly. My additional comments would just be, not to be redundant, is just that to assess your case at the beginning level. We really are proactive at the department and really try to look at the case before you've even issued, for instance, in a career service case, the intent letter. We try to review as much documentation as we can. We try to talk to the key players before we've even issued the intent letter. If the intent letter is actually given, then sometimes you have the opportunity at the predetermination conference, if selected, to also use that as a tool to assess your case. Because I've found that hearing the employee's point of view is very helpful, and it really helps you evaluate your strengths and weaknesses. After that, if it goes to PERC, for instance, then I've been very successful, or the department has been very successful in settling cases pre-suit, pre-lawsuit, if it has a component of the unemployment. So, for instance, if someone has filed already at PERC, and this is termination cases, obviously, and they also have the unemployment component, then sometimes they are very interested in settling. If you won't challenge their unemployment claim that they've been denied, they'd be glad to settle that so they don't have to pay the money back. They'd like to settle everything. Additionally, if there's been an Inspector General report, I like to look at that. I don't just read the report. I really like to delve into that. I look at the exhibits that go along with it. I listen to any and all recorded statements. Just as much information as we can obtain prior to going forward is what we do at DFS. I just wanted to talk briefly about arbitrations, because I actually have represented the department in 3 arbitrations. And I felt like it was the Wild Wild West, because I'd never had a case where I didn't have evidence rules and everything was just whatever came in, came in. I didn't have any exhibits ahead of time. I didn't have any, who are your witness statements, none of that. And so we were successful in 2 of them, and then we had one recently where we were not successful. However, with the help of Renee and Mary Beth Bohannon, we actually took that arbitration award to circuit court and got a favorable ruling and had that arbitration award vacated for a new hearing, which is unheard of. However, I can't take credit yet, or we can't, because it's now presently pending here at the first DCA. But we're very hopeful that that will be sustained. It was Judge Hankinson's. It was a great order, and we are very proud of that one. Additionally, I would just say that I have also experienced a high level of whistleblower cases. I feel like that's the new trend. We've also had to deal with reinstatement hearings recently. They are not fun, And all I could reiterate again is document, 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 and especially if you have a problem employee, put something in that personnel file so that you can prevent problems later on at perhaps a whistleblower reinstatement hearing. Thank you. So now we'll